But I just want to tell my learned friend here that these are not theories of case that both of us will have to posit. And first of all, your reference to Article 296C and saying that President Mahama has breached because there was no CI regulating the whole process, I want to tell you on all fours that it has received judicial interpretation in the case of Russell France versus EC and AG, where the court said that if we were to apply the provisions and we were to go by your theory, it will lead to what the court described as a nuclear meltdown. And so please, you have to revise the law again. Secondly,
you've not made any point. What do you? Well, you just stated the principle. What does it mean?
No, my point is that
it's established a correlation.
There is an interpretation on what you are quoting, so it can't be what I say versus what you say. The court said that it is not every time that where a person who is not a judge or a judicial officer is exercising their discretion, that person must use a CI to regulate it, because the president makes decisions every time. The decision to build a hospital is a discretionary decision.
But Utaderi's case is clear. The principle in Utaderi's case is clear. But when it comes to the removal of a superior court, you have to go by this, the 296.
You make reference to Article 14610, and you say that because of the provisions, President Mahama has breached. I mean, I don't know. It is not enough to say that person has breached, because as lawyers, we know that the principle is where a party makes an averment capable of proof. You do not merely repeat the averment. And that's exactly what you're doing. You're saying, apart from the laws, there are values, there are conscience, there are moral codes.
No, stick to the law. Stick to the law. You were making a point. Come back. Don't run away. Beatrice, come back.
I was very civil when you were
Beatrice, I want to understand something.
You were actually not speaking law, but I kept quiet, so oblige me.
Oh, you want to start on that?
Even if you think I am not, you oblige me.
You want to start on that?
Yes, let's you made some propositions like the values, the conscience, the moral codes. What you failed to show us was what values have been breached. What is the conscience? What is unconscionable about it? And whose morality has been breached? You said that it is not reasonable, and yet failed to demonstrate how unreasonable it is. My point is that we cannot merely say that it is unfair. We cannot merely say that. And your provisions you've quoted, I've told you, this has received judicial interpretation. Now, the issue about if you were removed as a Supreme Court judge, or as a Chief Justice, then there is a school of thought that says that you've not been removed as a judge. In the J. Chun's case, in the GBA case, it is so clear. The court, Justice Bamford Addo, said that the person has to have a certain moral standing to be a Supreme Court judge. And it is after that you can be a Supreme Court judge. So how is it that the standard for even removing a Chief Justice is higher than for removing a normal Superior Court judge? So how is it that you were able to meet the higher standard, but the lower standard? I mean, these are absurd decisions. And these things, we have Supreme Court decisions. If the NPP says that this is not wrong, like they used to do in opposition, I expect them to go to court and challenge it. I expect them to file for interpretation and say that, you know what, the current judicial precedents we have, which of course is binding on everybody, we think that we should change it. If they have any recommendations on how the removal of a Chief Justice or a Superior Court of Judicature should be removed, the Constitutional Review Commission is available. I urge them to make those things available. Then we can move forward. But let me conclude and say that nobody can throw mud at President Mahama. Nobody can say that President Mahama has not been a Democrat. Nobody can say that President Mahama has breached the provisions. And I am very clear in my mind that if President Mahama at any point in time refused to exercise the powers imposed on him in this constitution, the mini minority in parliament will begin an impeachment process and say that you disrespected the constitution. I think we must advance the argument and say that as a people, I'm happy and I want to listen to other arguments about how we can do this so that our checkered history will reflect that together this is where we are, and we think that we are calling for reforms. Otherwise, you cannot stay in President Mahama.
You know, Beatrice has a very subtle way of undermining his colleagues on set.
I didn't even undermine, but if you feel undermined, I apologize.
No, but I mean,
I didn't.
This is my first time of being on set with her. Proud to my coming. When I
but she's been sweet. Right? She's been very sweet.
Yes,
very sweet to him.
Yes, but to make comments like you are not speaking.
No, if you feel offended, I'm very sorry.
No, but you know it was not a fair comment because we are engaging on the basis of the constitution.
Me, I like you a lot. So I
she's patronizing.
Beatrice Annan. Oh no. Please go ahead.
I like the Japan's team. Actually, all my friends are there.
You mean you are?
Oh, actually, all my friends are
team.
All my friends are Team Kennedy Japan.
I see. Interesting.
Just Tapo.
Okay.
Yeah. So when I made the point about reasonability and we are people of conscience, it is in no way to jettison the position of the law. I was just building up my case and also even look at or situate the matter within the context of how the ordinary Ghanaian will feel about it.
Okay.
Law does not jettison questionability. Even questionability is a subset in law. And so when you are taking any decision, in the spirit of even our national coherence and the growth of state institutions, and not to appear as though you are attacking one state institution and the other. You also need to be mindful of the mood of the nation and political realities. Of course, I mean, that is not, it answers your question. That is not to suggest that if there is any wrongdoing but by anyone, it should not be addressed. That's why quickly I then switch into the legal aspect. I made the point that the CJ is not beyond reproach. No two ways about that. But we can also not be dismissive of the politics the MPP and NDC plays in this country, to the extent that we hide under the law to perpetuate some of this injustice that ultimately will affect our country as a whole. Of course, I've heard a lot of instances and examples about Charlotte Osei trying to equalize. Let it be on record that even with how Charlotte Osei's case was handled, it was not everybody in MPP, but every Ghanaian that loved it. People may have their own reservations, but collectively, the party ought to take responsibility for it. Just like this one, the NDC as a party and the government is also taking responsibility for it. But Moro, if the removal of the CJ, as just like it's being discussed within the political space, is to avenge that of the removal of Charlotte Osei, then there's no basis or legal basis of even the removal in the first place. Of course, I mean, like I stated, as for legal basis, they will attempt to get reasons to justify. Do you know that if you go to court, when a judge gives judgment, you give reasons for the judgment. But as to whether those reasons are reasonable, that is the cause of worry. And those are the questions that I'm asking, whether or not the reason that has been ascribed is indeed reasonable. For me, I see those reasons as an excuse.
Okay.
Just designed to label the woman as bad. Call the kettle, the pot black. Okay. Call the kettle black so that you'll be able to remove it. That's exactly what we are seeing now.
Okay.
But in terms of the legalities, and of course, I mean, I want to place emphasis on the point that I made again, that there are some constitutional breaches and violations that has occurred in the course of this process, prior and even during her substantive removal. Okay. That if you look at even the remover, she was being removed in the capacity as a CG, not necessarily as a capacity as a justice of the Superior Court.
Okay.
I agree that ultimately, if you are appointed as a justice, as a CG, you obviously, based on operation of Article 128, you are enjoined to become the head of the Supreme Court. So automatically, you become the part of the Superior Court or part of the Supreme Court. But I'm saying that if you look at the appointment of the CJ, vis-a-vis the appointment of the justices of the Superior Court, if the framers of the Constitution had intended it to be the same, they would have made it clear.
Okay.
And so if there are different modes of appointment, you cannot suggest to me conclusively that their removal also is the same.
Okay.
And by virtue of that, if the CJ has been removed in the capacity of a CJ, automatically it makes her also lose her status as the Justice of the Supreme Court.
Okay.
No. Again, if you even go beyond that and compare Article 1464 to 1466, in terms of even the composition of the panel, that ought to look into the prima facie case, in terms of even the determination of the prima facie case, and in terms of even the transmission of the work of the committee that sat on the matter.
Okay.
They are totally different in terms of the justice of the Supreme Court or a Superior Court and also that of the CJ. So maybe at best, what the NDC should have done was to have, after removal of the CJ, they should have initiated a different process also to remove her in the capacity as a justice of the Superior Court.
Okay.
Of course, I mean, no, this is not jeopardy. But the point is that, Moro, the point is that...
Are you aware she pleaded
no, I'm coming, respectfully. The point is that in the Constitution, it is not clear. There is no provision. All what Beatrice is doing is making assumptions based on her own interpretation that the moment she loses her status as a CJ, automatically she forfeits also the status as a justice of the Superior Court. And I'm saying that there is no clear provision of the Constitution.
Why is this matter so important to you? No, you've dwelled on it for a while.
Yeah, I've dwelled on it for a while because I want to make a point that in respect of her removal as a CJ, it was constitutional. But in respect of her removal as a justice of the Supreme Court, it's unconstitutional.
Okay.
And on that basis, the president do not have such powers, especially within this very same procedure, to do that.
All right.
It ought to be done through a different or an entirely different procedure, also spelled out under Article 146, but of course with a very different approach.
Okay.
Because in that case, you'll be losing her status as a capacity of the Justice of the Supreme Court, not the CJ.
Okay.
So when Beatrice presents it and make it look like I don't know law and I'm not speaking law, I want to let Beatrice know that in a circumstance like this, where the Constitution is not very, very clear, and different school of thought has arisen.
Okay.
The Constitution enjoins us under Article 2 to go to the Supreme Court for interpretation.
That's fine.
Which I'm not sure there should be any dispute about it.
I'm sure you would want to lead that.
His 10 minutes. Just a quick reaction.
You have just 5
If you
minutes.
look at Article 146,
Okay.
the whole Article 146 is on the removal of the justices of the Superior Court. So the side note says removal of justices of Superior Court and chairman of the Regional Tribunal. The side notes here are not put for fun.
Okay.
They are actually what we call aids to interpretation.
Okay.
So that in the event that someone may think that the process may be different from that of a Superior Court, we call into that side note as an aid.
Okay.
It provides you the procedure on how a justice of a Superior Court should be removed.
Right.
And then issues a caveat that, however, if it is the Chief Justice, don't use procedure A.
2 minutes.
No, we're done actually.
No, you are done.
In fact, we're even told they're taking us off,
So-
unfortunately. They're taking us off.
It is very
in 30
misleading.
seconds.
It is very misleading for
Let's say, I
anybody.
want to comment on this
let her
briefly.
land, please.
No.
You're done with your
It
time,
is
so
very
let her, just 30
misleading
seconds.
that someone would suggest
Yeah,
that,
you are treating me on air.
that you know what, let's now trigger a second process to remove the person. In any case, for those who don't know, one of the greatest legal arguments.
Why
that
did the
Chief
framers
Justice-
divide the two?
Okay.
The
one
Chief
of
Justice, if they are all Superior Court judges, why did the framers divide the two?
The
Okay.
biggest
The procedure.
argument the Chief Justice made, which she even made public, is res judicata. And why did she say that was res judicata? She says that a prima facie case has been determined. So why do I even have to provide answers? I can imagine what defense, but you see, I am that person who supports my friends. That's why my friends will bear me out. And so as learned friend here, I want to encourage him.
As not speaking law.
Yes, I want to encourage him that he should challenge this. You know, sometimes you have to test the law.
You go to court.
That you should go to the Supreme Court and invoke the original jurisdiction or the interpretative jurisdiction of the Supreme Court on whether or not after you proceed or you start Article 1466, you have to come back again and start another procedure.
Whether or not the removal of the
I'm happy to look at some of your written submissions for you, and I'll support you. So I want to support him and encourage him. You know, sometimes when you're in the position, these are some of the things that you have to do. So I encourage you.
Give the last
but I think that is not the position of the law.
Okay.
The point has to be made. And we've had arguments about there was a time when apartheid was legal. There was a time when slavery was legal. The people who said slavery was illegal
you said there was no
demonstrated. No,
One more minute. I've just.
The people who
She's about to learn. I'll give you. No, I'll give you 2 minutes.
The people who
I'll give you
said
2 minutes.
apartheid was illegal, that slavery was also illegal,
Yeah.
did not just say it was illegal. They demonstrated why. They spoke about the liberty of the individual.
Okay.
They spoke about the fact that we are all one person in the case of apartheid.
Okay.
They spoke about the fact that we ownership of land. So we want to hear you. We want to know why this, even though legal, is unethical or immoral. It is not enough that because this Chief Justice, no.
Okay. All right.
But in any case, I would love to hear your written submission.
Yes.
You had your
I didn't even say
2 minutes.
I didn't mean
encourage
see
you to challenge this.
Beatrice,
It will be very beautiful.
Beatrice,
Please go ahead.
Beatrice presents and make it appear as though my submission was that it's on some moral or some ethical issues. No, far from that.
It's one submission.
It's one. Yes.
And I'm allowed to.
Yeah,
I'm allowed
very
to
well, very well.
respond to
Beatrice,
that
Beatrice,
part of
I just want to talk about comment
But the
briefly.
time is mine, so I
Oh,
can.
No, on the 146, which talks about the removal, that she was trying to lump up the two. If indeed the framers of the Constitution had intended to lump up the two, they would have treated the removal of the Chief Justice as also a removal of a Justice of the Superior Court. They wouldn't have distinguished the two.
Okay.
So that should, make it clear that we need a constitutional interpretation on that.
Okay.
Maybe, you are advising me, I'll go to court and get a constitutional
So you
interpretation.
get
But in respect of her removal as a CJ, in terms of the legal procedure and that removal, of course, aside the 296 where they violated, nothing wrong with it. But in respect of her removal as a Justice of the Superior Court, that one is constitutionally flawed, which some of us will go to the Superior Court to.